now asking those beneficiaries to, in effect, gift those assets back to the decedent to pay for their final expenses. Number two, what happens if someone dies out of order? You know, there's no detail that can be provided in this plan. You're really subject to what the institutional form says and allows for. So you may be limited if you have a minor in your family and you want to maybe create a trust for that minor so that the minor doesn't get the assets immediately should something happen to you. Typically, a bank form or a brokerage form would not allow you to put that type of detail in the beneficiary designation on the institution. Also, if somebody were to die out of order, say you've got 2 children and each of your kids have children, and one of your kids were to predecease, what would happen to that 50% share? Does it go on to the surviving child? Does the 50% share go on to his or her children? You just don't know. Again, each institution's form might say something different. So you're going to get an outcome that you maybe wouldn't have wanted. So that's really going on to that third point is, you know, what does each beneficiary designation at each separate institution say? There's a lack of coordination amongst all the different assets that the person has, and it's just it's an unsuccessful outcome most of the time. The other con is the will or trust is not used. You know, you think of people that prepare these elaborate wills or elaborate trusts, and they say what they want. They say they want assets to pass to their kids in a trust. They might have charitable desires. Well, if you add on a beneficiary designation, and now you leave the asset directly to the beneficiaries, your will or trust is not being used because at death, your assets are not passing through those documents and they're avoided. So that's often an outcome I see. Somebody will have a good plan in place, and somebody at the bank, a teller or some other person, financial planner, will say, well, let's just put a beneficiary designation on it. And it's an unintended consequence of the estate plan has been bypassed. So, you know, I always tell clients, I say, gosh, clients, there's just too many cons to use this type of planning. It's not a coordinated approach. It's just kind of a scattered type approach. And oftentimes just doesn't make sense. The second type of plan is a will-based plan. What this means is that the will is just simply the legal document that gives instructions as to the distribution of your assets after death. A will would be the place where guardians would be appointed if you had minor children. A will is the document, it allows you to communicate your wishes clearly and precisely. Now, you know, going back to the beneficiary designations, if you do not have beneficiaries on your accounts and you have a will-based plan, now all of your assets would pass pursuant to your will, and your will could have all of the detail and coordination as to where you'd want your assets to pass and how you'd want those to pass. So your will can be as detailed as you want, or it can be as kind of basic as you want. It's really up to each person. You know, we were talking about who needs an estate plan. Well, I say, gosh, first people, everybody needs a plan. Everyone needs at least a healthcare power of attorney. And if you have minor children, you absolutely need an estate plan to say, where do you want your minor kids to go? Who's going to be in charge of caring for them? So I'm going to go back out. I'm going to pop in for one more video. Give me just a sec. I'll be right back. Oops. Let's see, bear with me. And Molly, are you there? I cannot get back to the Zoom. Are you seeing the screen, Molly?
No, we don't see the screen, just the faces or squares.
Okay, let's see, give me a sec here. Okay, here we go. All right, now you got it? Sorry about that. Here we go.
February, a cottage Revocable was headed to a Badger basketball game when a driver flew into the opposite lane, killing them both and leaving their twin boys without parents.
Tonight only on News 3, Keely Arthur shares how the family they left behind is trying to share an important message. She joins us in the studio with more. Keely, Kirk Uren and Jenny Steiner always planned to create a will, but on February 12th, they ran out of time to do that. It was a misstep their family says made this tragedy even worse, and they want to help everyone they can avoid it. Their hands full with twins Caden and Grayson. Hi, Grayson. Kirk Uren and Jenny Steiner ran a tight ship. Control freaks. Making sure the boys were taken care of every minute of every day. Having posted notes everywhere and information things, you know, what they had to do, their list of what to do. When they weren't with little Caden and Grayson, you could find the two watching Badger basketball, which is what they planned for February 12th. It's supposed to be a great day. And it's just how fast something can change in a split second. On their way to the Kohl Center, they were hit when a driver from the opposite lane flew into their car, killing Kirk instantly. Jenny succumbed to her injuries 2 weeks later. Kirk's mother, Jerry Uren, was watching the twins when it happened. And I saw the two officers out there, so I knew it was bad news. But Jerry didn't have much time to grieve. The parents who left nothing to chance in life left everything unresolved in death, including who would take care of Caden and Grayson. That was even on the last list that was on the counter, make the will, and they never did get it done.
It's very overlooked. 60% of Americans have no estate plan whatsoever.
The state attorney, Nelson Donovan, says unfortunately the Uren situation is a common one.
People don't want to go to the expense of planning. People don't want to talk to attorneys. It's just facing mortality, and a lot of people don't want to do that in any way, shape, or form.
But by spending the time and money now, you could be saving your loved ones in the future.
So that you don't have friction in the family, that you don't have this conflict that occurs.
There are a number of ways to create a will.
All right, Molly, I'm going to come back in quick. Let's see if I can do come back to the PowerPoint. All right, so we saw a video there, and I didn't play the whole thing, and if you keep watching that video, you'll see in it that that was the mother of one of the parents that deceased, and she makes a comment later on in the video. She says, well, we think we know what Kurt and Jenny wanted as far as who to take care of the kids, but we're not sure, and now the family is wondering who should be in charge. And so you can just tell by watching the video that it's already kind of setting up a family issue as to who's going to take care of these kids. So it's just not something you want to leave to chance. It's not something you want to leave to family to try to decide. It sets things up for arguments. And if you have minor kids, you just have to have a will that says who would be in charge of the kid should something happen. All right, so to continue on with our will-based plan, some pros of the will-based plan. There's not as many documents to draft as a trust-based estate plan. You'll see later that we do have a few more documents if you decide to do a revocable trust-based plan. So I would say a pro of a will is it's a little simpler to prepare. A pro is it can be detailed or as simple as needed. Again, the will really serves as the filter. So all of your assets pass according to your will, and then your will provides all the detail as to where things go. The will is a simple, straightforward way. It gets the job done. Some cons to will-based planning. You know, I had said before that if anything passes pursuant to the will, you're subject to a probate proceeding. A probate proceeding is where you've got the probate court involved, and the way that really works is that the will nominates a personal representative, and the personal representative is the person or entity that's named to handle your affairs upon death. However, the personal representative doesn't have any authority to act until they've actually been appointed, or I sometimes say blessed by the court. And in order to get blessed by the court, you know, the process is a personal representative would normally come to a lawyer. The lawyer would draft a stack of documents, and then we'd send those documents off to the probate court. The probate court reviews the documents, stamps a letter. It's called a domiciliary letter. And once the personal representative has that letter, now they have the authority to go to the various banks and financial companies or wherever the assets are and say, hey, everybody, I am now the appointed personal representative. Here's my letter of authority from the court. Give me the asset, and I'm going to take the asset and pass it out according to what the will says. So you think about that process for a second, and there is delay, right? Before that personal representative can act, there's delay until the court gets around to stamping that domiciliary letter to give the person authority. We're very lucky in Wisconsin. That process is normally 2, at the high end, 3 weeks before the court can turn that paperwork around. But even still, you think of that as far as there's a couple-week delay before anybody can act on behalf of the decedent's assets. Sometimes that's not a big deal. You think, go back to March of this year, COVID striking, the stock market is in free fall. You could imagine the value of the decedent's estate on, you know, March 1st versus March 14th. I'm making up dates, but you could imagine with that market falling as fast as it did. And if nobody has the authority to get out of the market, what an impact that can have on a estate. I had a client in California. She had submitted paperwork to the court. She was 6 months out and still did not have her authority letters from the court. And she said it was due to a backlog of the court in California. Apparently they were so far behind, she just did not have approval letters or authority letters to act. So that can be a significant time potentially if you're in a different state. The second part that I think is a downside of a will-based plan is you need approval from all interested parties. So you need approval first as to that it's actually the last will of the decedent. And then second, the interested parties need to approve of the personal representative that's named in the document, that they're okay person to serve. And so the court or Wisconsin law requires that all interested parties, get notice of the proceeding and also approve of the will and approve of the personal representative. And an interested party is anybody that's named in the will and also the legal heirs. You think of a legal heir. Well, legal heir is defined by Wisconsin statutes. And the best example I could give for this is a second marriage where there were children from a prior marriage. In that situation, the legal heirs would be the current spouse, and it would also be the children of the decedent from the prior marriage. So the children from the prior marriage step up to the same level as the current spouse. So before the will could be admitted, before the personal representative could be appointed, all of those folks have to get notice. They also have to approve. And if they don't approve, there's a court hearing on the matter to decide whether what's being asked is acceptable. So, you know, depending on family makeup and relationships, again, you could be asking for an argument by doing a will-based plan just simply based on the people that have to get notice of this. A third downside of a will-based plan is your will is filed with the court. Upon death, it's a requirement in our state that your original will gets sent to the probate court, and it becomes a public document and public record, meaning that anybody could go down to the courthouse. For instance, my name, punch in Tim Sugar, up pops Tim's will, and potentially up pops all of the assets that passed according to Tim's will. So it's a public proceeding, it's a public document, and anybody can see where I would have left my assets and potentially how many assets transferred. The third type of planning is a revocable trust-based estate plan. I told you at the beginning that I work for a trust company, so I am biased towards revocable trust planning. I think because of that, and I think also because now that I'm in private practice and I'm doing probates and trust terminations, and I also saw this at the bank, probate is just a real pain, and it takes time, and it's you have a court involvement versus a revocable trust, which is a much simpler process should somebody pass away. I guess I just say that to you plainly, just so you know where I'm coming from, that my bias is always be towards revocable trust planning. So the only difference between a will plan and a trust plan is, again, what document is passing the assets. With a revocable trust plan, you leave all of your assets to your trust, and then your trust coordinates the distribution of the assets. Your will, you still have a will with the trust plan. However, your will just serves as a backup. Your will would be a 2-page document, and it would say, if something happens to me and I have an asset left in my individual name and I need a probate, I appoint a personal representative to go to the court, and personal representative, your only job is to go and get that asset, transfer it to the trust, and distribute it according to what the trust says. So your will becomes a backup in a trust plan. Ideally, it would never be used because all of your assets would flow right to the trust and would not be left in your name upon death, and no probate would be needed. So pros of a trust plan. A trust appoints a successor trustee. We talked earlier about a will appointing a personal representative. Your trust appoints a successor trustee. The successor trustee has the same job as a personal representative to go out, gather the assets of the trust, and distribute now the assets according to what the trust says. A successor trustee has the immediate authority to act. There's no court involvement. We're not waiting for the court to give those authority letters. Instead, the successor trustee has the immediate authority to act on behalf of the trust. So there's no court involvement, there's no delay. Just like a will, drafting of a trust can be as simple or as detailed as needed. Instead of the will serving as your filter, now the trust does. The will is, the trust is a private document. Only the beneficiaries of the trust see what the trust says. It doesn't get filed with the court. Nobody else would see where your assets are going or how many assets are passing, except for the beneficiaries of the trust. So it's a private proceeding. Of course, there are some cons to trust-based plans. You know, generally there's more documents to draft, so there's more upfront cost. Like I said, you've got a trust, you also have a will, so there's more documents. Somebody has to fund the trust, and what I mean by funding the trust is, again, making sure that upon death, there are no assets left in the decedent's name. So there's 2 ways to do that. During lifetime, you can retitle the account to the name of the trust, or you can add a beneficiary designation to the trust. You know, you take a simple example, a simple checking account. If you created a revocable trust, you could go to the bank, say, bank, I created a trust. I want to change title of the checking account from my individual name to the trust's name. You've now funded the trust. Upon death, that account is in the trust and would pass according to what the trust says. Alternatively, you could say, bank, I created a revocable trust. I want to add a beneficiary designation, a payable on death, to my trust account. So a checking account stays in your individual name. Upon death, the payable on death designation controls, and that directs that asset directly to the trust. So again, the goal here is that no assets would be left in the name of the decedent at death. Everything passes to the trust. I put an exception in here for retirement accounts. Retirement accounts are, I'm going to put quotes up, special assets because of their tax deferred characteristics. I'm not going to go into detail about retirement accounts today. They can be left to the trust, but most of the time, retirement accounts are assets that are left directly to beneficiaries so that the beneficiaries can continue to grow those accounts on a tax deferred basis. All right, moving into some of the collateral documents. So those first options we talked about, beneficiary designation, wills, or trust, those controls where your assets go should something happen. These are additional assets that make up an estate plan. I call these the various collateral documents. And the first one here is a financial power of attorney. A financial power of attorney is a way to allow someone to manage your finances in the event you become incapacitated, or in the event you can't make decisions for yourself, or as the case in a lot of my elderly clients at the bank, they just didn't want to do the job anymore. They were very appreciative of when the bank could take over, and we were taking over as in our capacity as trustee, but taking over for things like paying bills, filing income tax returns, all of the things that you and I do in our financial lives. That is what a financial power of attorney could do for you. You don't necessarily have to be incapacitated. You could make this document effective immediately, meaning the day you sign it, that all of a sudden your financial power of attorney has the authority to act for you. Or you could say the document only becomes effective upon a doctor certifying incapacity. So financial power of attorney, who has the ability to act for you if you can't do it or you don't want to do it? Healthcare power of attorney. A healthcare power of attorney, this is going back to who has the authority to make decisions for you if you are incapacitated. For healthcare power of attorney, it is actually in the document that you would be incapacitated before your agents would be able to act for you. At our firm, we simply use the Wisconsin Healthcare Power of Attorney form. And the idea there is that this is a form that doctors would recognize. It's not a self-drafted form that when presented to the doctor, they would have to say, oh, geez, we've got to send this off to legal to review it before we can take action on it. Instead, we'd prefer to have it be a state form that is a recognizable form by doctors and that they're very comfortable acting underneath it. So I put a link to this form in the PowerPoint. You can just simply go on to Department of Health Services and up pops the healthcare power of attorney document. I always advise, well, you could do this on your own. There's several questions on this document. Do you want feeding tubes? Yes or no? Do you want to be admitted to a nursing home or community-based residential facility? Yes or no? These are questions that are often misinterpreted as far as the document goes. So my advice to you would be to have somebody that's filled these forms out review it with you to make sure that you're answering those questions appropriately. Another form we prepare, the HIPAA authorization. The HIPAA would say who can stay in the room with you, is talk to your doctor. You know, I think of this as who can call the hospital and say, hey, I heard that so-and-so is at the hospital. What's going on? Can you tell me about their condition and how are they doing? We do a living will. A living will is direction to your doctor about how you'd want your care handled. Should you be in a situation that you can't make decisions for yourself? I think of this really as end-of-life care, feeding tubes and paddles. This next one is called the Authorization for Final Disposition. I always call this the creepy form. This form comes out of the state of Wisconsin, northern Wisconsin, where mom passed away, survived by 2 daughters. One daughter wanted burial, one daughter wanted cremation. Mom sat in the cooler until the courts could figure it out. So the result of that case is they came up with this form, and this form designates who's in charge, who actually gets to make that decision regarding what happens to remains. This came up again recently with the case. There was a minor that passed away, mom in Wisconsin, dad in Florida, divorced parents, and mom wanted her in Wisconsin, dad wanted her in Florida. And she ended up going to Florida because the mom had some sort of negligence in the daughter passing away. But it does come up. It is the creepy form, but it does come up occasionally. If you don't do the form, the statutes would control, and statutes would say, first, spouse gets to decide. If not spouse, a majority of my children get to make that decision. All right, so this next kind of topic is really about conversations and how to have conversations. I think I started this with the idea that my friend came to me and said, I would like to at least talk to my parents about this topic. And interested in what they have in place and how do I do that? And is there any kind of rules around this? And I do it. I said, well, absolutely. Of course there's rules. There is the 40-70 rule. And this is a rule that says by the time you approach age 40 and you have a loved one around age 70, that you should have the talk. And the talk includes things such as, living choices, financial choices, healthcare, driving, estate planning, end of life decisions. These are all challenging topics, but they're topics that need to happen to have a successful outcome. Another question clients always ask me, Tim, should I share these documents with the agents that I'm naming? Should I share where my estate and assets are going? That's a tough question for me to answer, but I will tell you that the most successful outcomes I see with estate planning is where conversations have happened, where everybody is aware who's going to be acting and in what capacity, and also where everybody has a sense for what their inheritance is, how the inheritance is going to be split, especially if things are being left unequally for one reason or another. Maybe two kids are getting their inheritances outright. Maybe one child had some substance abuse issues along the way and maybe getting their share in some sort of trust to protect that child. Well, you can imagine the hard feelings that one child might have should they had not had the opportunity to talk with mom and dad about reasons why their share is being left differently than their siblings' shares. And I've had those conversations with these beneficiaries. They're not fun conversations to have. They wish they would have had the ability to talk to their mom and dad about why they're making those choices that they have, and they don't get the chance to do it. So to the extent that it's something that is appropriate in a family situation, I always try to tell people, to the extent you're comfortable, have the conversations ahead of time. It makes things so much easier at the end of it. I also think, these conversations are twofold. First, the first question, are the legal documents in place? From the child parent perspective, what documents do mom and dad have? We just heard estate planning is not done by 60% of the people out there. It's very important to make sure that legal documents are in place, to make sure from a child to a parent that mom and dad have those documents in place, naming who they want to make things as smooth as possible. So the first question is, are the documents in place? Do you have an estate plan? What does that look like? Who's acting? All of those things. I think the second question that people sometimes don't think about, what do the financial affairs look like? Are there enough resources to care for parents during lifetime? Or is this a burden that's going to fall on the kids? We all are planning retirements and talking with financial planners, and a huge hiccup to our plans might be the requirement to also care for our parents or to provide for their care in some sort of assisted living or in-home, and what kind of effect that could have on your planning. So I think that's a second conversation that, if possible, should be had. Just doing a couple quick Google searches, on the web, this is nothing fancy, but there's difficult topics for children to speak parents about, and this was a poll. 42% said needing to leave the home, 30% losing driving privileges, 11% money, finances, 11% health, and not categorized was none. But all very difficult conversations, but better to have those conversations before there's some sort of emergency or before there's an actual need to leave the house, just to get a sense for what somebody, might want. Also, some obstacles as far as having those conversations. I think there's these roles that people perceive themselves in, a parent-child role, and how difficult that can be when you've been the child all the way along, and now here you are trying to come to the forefront and say, Mom or Dad, how can I take care of you? And that's a role reversal and awfully hard sometimes to make that switch. But I always tell clients too, it's something that happens over time. this is not one conversation, it's multiple conversations where maybe it's one conversation where you just bring the topic up. The next time you try to dive into more of the details. What documents do you have in place? Or do you have, it's just a simple question, do you have a healthcare power of attorney in place? Something just to get the conversation started. This isn't something that you try to kind of bite off in one fell swoop. I think it's, you're taking little nibbles, so to speak, to try to find out as much as you can about the situation and to help as much as you can. That's what you're doing at the end of the day. There was another poll that said 46% of baby boomers said they'd like to know more about their parents' end-of-life wishes, including medical directives. I have family that's in the ER, and one of the things that they always tell me is one of the hardest things is when they call a agent that's named under a healthcare power of attorney, and the agent answers and says, "What? I'm named? Oh my gosh, I have no idea what my mom or dad or this person in here would want. I don't know. I didn't even know that I was named." They call that a ghost power of attorney. So I think that kind of falls in line with this research, is that it's just so important to have those conversations and to know what your loved one would want. I put in here, just as from the Home Instead Senior Care website, I think it gives some other tips as how for children to communicate with aging parents. I'm not going to go through them all. If you want to kind of research or look at those at the end of it, you can. The one that I liked, I think that resonated with me anyways, was this: maximize the independence. As I'm thinking about what my parents would want, they've told me multiple times they want to stay in their house. And so I think of, these professional caregiving services and talking to them about, well, how would we make sure to get that done for you guys? I want to leave enough time for questions, so I'm going to kind of buzz through these pretty quickly. But I think another part of estate planning in conversations and making sure you have a successful outcome comes back to teamwork. If you have a financial planner, some people do, some people choose to do it on their own. But if you have a financial planner, they can help to facilitate a lot of these conversations. They can help make sure that the estate plan is up to date. Oftentimes in my role at the bank, I would have a copy of my client's estate plans. As laws would change, tax laws would change, family situations changed. Because I was visiting with the client at least annually, oftentimes a quarter annually, I really knew the client's situation. And when their circumstance changed, I would be able to relate that to their estate plan and say, gosh, your healthcare power of attorney, the person you named just passed away. It's time to go get your documents updated. Go back and see your lawyer. And so where I'd say clients don't necessarily think about this stuff all the time. They do their plan, they put it away, and it collects dust. Financial planners are perfectly situated to have a copy of the plan, pull that plan out at the annual meeting, and literally just hit the high points and make sure that it still makes sense. A financial planner is also on the lookout for change of laws. We had a huge change in retirement laws January of this year, and that really affected estate plans, and a lot of plans have had to have been needed to be refreshed and redone. A financial planner, if they've got a copy of your plan, they are able to flag that and help you get back to an attorney to get that updated. So, I think utilizing, if you have a financial planner, utilizing him or her to help keep your plan up to date is just part of what I would say teamwork that helps for successful outcomes. A financial planner can also help with family meetings and discussion around estate planning. These are folks that are used to having these difficult conversations, and oftentimes they can pull multiple generations together and have that conversation if the family is open to it. And as a whole, a family can do better planning, maybe better financial planning, maybe better estate planning. What if the parents would like to leave their inheritance to a son or daughter, and the son or daughter are saying, hey, we've received other inheritances maybe from the other family members, and maybe they say, gosh, we don't want it, we don't need it, and in fact, if it was given to us, maybe that would negatively affect our estate as far as taxes that might be due, and potentially those assets should be left to grandchildren or other family members. So when you start getting together and you start talking with the generations, potentially there's options for, again, more successful outcomes. The planner, again, would help with, I'm looking at that third point, if there's a trust plan, making sure assets are titled in the name of the trust or payable on death to the trust. They can also help coordinate these things and make sure that they're work in place and complement the estate plan. The financial planner can help with investment strategies and, you know, if there's different goals of various trusts, sometimes trusts are put in place instead of revocable trust. There's something called irrevocable trusts. Irrevocable trust, the easiest example there might be for that child that has a substance abuse issue. And a financial planner can help as far as, well, how do you invest assets like that? Are we trying to generate income so that we can get income out to this person to provide for their living expenses? Or if they don't have a current need for income, do you know, have it more invested in stocks to provide for a growth within the trust? So each trust might have its own goal, and a financial planner can kind of help around that as far as how do we invest the assets within the trust that make the most sense for that document. All right, I'm going to wrap it up there so we have time for questions. Again, I'm at Niter & Boucher. Our firm is really only a business law firm and estate planning law firm. Within that area, you know, we do succession planning, we have real estate, but primarily those are the areas that the firm practices in. And one of the reasons I joined the firm is because they only practice, we only practice in these areas. I think we do these areas very well, and they complement each other. So we're not into family law, we don't do criminal law, we only focus on these areas, and these areas are so related that I think it makes for good planning and again, good outcomes for business owners and clients in general. All right, so let's turn it over to, if there's any questions out there, happy to. Molly, if you want to unmute, or maybe if you need to unmute, you can click unmute in the upper right of your box or wherever it is on your screen, and happy to field any questions that might be out there. And I'm not seeing Molly on the chat. Is there would chats?
If you unshare your screen, then the chat will pop up too.
Okay. Got it. Chat. Okay, yeah, we've got.
There are a few questions there waiting for you, Timmy.
All right, couple questions. Are you sharing out your deck? Happy to do that. I would, Molly, I'll lean on you as to how to pass that out, but happy to share the deck so anybody can look at it if they want to. Second question.
Yep, I'll share it with the attendees once you send it over to me.
Okay, great. How might having assets in multiple state jurisdictions impact the documentation and planning? That's a great question. You know, let's say you have a cabin in Michigan, a lot of clients, or a home in Arizona. And if you have one of these assets in a different state, and the asset is not titled in the name of the trust or payable on death to the trust, now you have a probate in that state. So oftentimes the reason a revocable trust is used is to avoid what we call ancillary probate, and that's the need for a probate proceeding in the state where the decedent has other assets. So, you know, if you had a second home in a different state, now I'm really recommending a trust to you to make sure that probate's avoided both in the state of Wisconsin and also in the state that you might have that other asset in. Great question. Got another question. Okay, I think I've got all of them. Is there anything else out there as far as live questions or other chat questions?
Timmy, I think Matt has a question. It says, if I have a trust, if I have a trust when I start a new company, such as a C Corp, should my trust own the founder's stock? Oh,
yeah, right on. You know, not necessarily. I think with stock, again, we can do that payable on death designation, so that should something happen, the stock would immediately pass to the trust and pass according to what the trust says. You don't necessarily have to have it in the trust. You really have those options either way. From an estate planning perspective, I don't necessarily care if the trust owns it or if we have a payable on death to the trust. The goal is no assets left in the individual name. Let's see, the next one. What if parents own rental properties? Should those be moved into the trust or maintained in an LLC? Yeah, great question. You know, those should be maintained in an LLC. The LLC is the entity that can help provide protection from creditors or other things. I mean, that's the reason you do an LLC, is to shield the rest of your assets, so that should something happen within the LLC, the only assets that are subject to that action would be the LLC assets. So the way you handle an LLC from an estate planning perspective is upon death, we do a form that transfers the LLC to the trust to be distributed according to what the trust says. So the LLC stays intact, it just becomes an asset of the trust after death. Yeah, great question. Let's see, next one. What is the rough difference between setting up and managing a will versus a trust? You know, really nothing. As far as once it's set up, they both operate the same. All of your assets with the trust, they're still taxed to your Social Security number. From a tax perspective, it's a non-entity. It doesn't matter one way or the other. Now, oh, sorry, what is the rough cost? So I get that question all the time. Tim, tell me what the cost of an estate plan is going to cost. And I have a hard time answering that without diving into the client's situation. And I say that because each situation is so different. Are we talking about somebody that has special needs kids? Are we talking about somebody that has, you know, strange assets? Are we doing trusts for kids? Are we doing trusts for grandkids? There's so many variables when it comes to estate planning that, you know, the way I do it is I charge on an hourly basis. I would have a meeting with a client up front, figure out the goals and objectives for their plans and what they would want. And then after I have a sense for the outline of the estate plan and what clients want, then I'm able to give a range to say, well, this type of plan will cost somewhere between this and this. Now, I can tell you that I've done wills for as little as you know, $800, and I've done trust plans for north of $20,000. It's just so dependent. Are we talking about a estate plan that's subject to inheritance tax, estate tax? That makes a big difference. So each one, I just can't give you a difference as far as the cost. It's just going to depend on what the client wants in there and what kind of details we're putting in. But as far as maintaining the two, they're really very similar to maintain. You know, the trust, you got a little more upfront work to direct assets to the trust, but once that's done, it's very simple to keep it that way and going forward. Any other questions or live questions? Feel free to unmute and ask away too, that's fine. Well, I'm not seeing any, Molly, but I guess I'll just take one more second, tell everybody thanks so much for attending, and certainly enjoyed presenting at Forward Fest. And Molly, thanks so much for being there to help with the technological side of things.
Thank you, Tim.
Really appreciate it. So thanks to everybody, much appreciated, and enjoy the rest of Forward Fest.
Thank you. Thank you very much. Bye, Tim. Bye, everybody. Thank you.
Bye, everybody.